If you look in your materials at the papers that the news media filed later in the Moussaoui proceedings in the Fourth Circuit, which lay out sort of the big picture view of the principles of access, you will see, as Ed and Henry noted, that what the media then knew, what the public then knew about the sealed materials came from unofficial sources, and although events, with the benefit of hindsight, suggest that we did correctly understand what was at issue in the sealed documents at that time, to this day we're not certain of that, and at that time we were largely guessing based on unofficial sources. That does make it hard to argue that the executive has been overbroad or just flat out wrong in designating material as confidential. But setting aside the classified information for a moment and returning to something that Ed pointed out, where the real issue arose in the Moussaoui case and public access became blocked in a substantial way was when the defendant, Mr. Moussaoui, was representing himself and filing, it's fair to say, invective-filled pleadings day after day after day, attacking Judge Brinkema, attacking the integrity of the court system, attacking the country, attacking various other people in the most unpleasant and personal terms. And perhaps understandably, after time, Judge Brinkema simply became tired of that, felt it was inappropriate for any number of reasons, reasonably so, but she ordered, in order to address that problem, that Mr. Moussaoui's pleadings all be filed under seal without a mechanism for addressing the issue of whether the constitutional or common law standards had been met. And it was at that point that a number of news organizations joined together to, as I said, gently remind the court that no matter how unpleasant or upsetting or vile those pleadings may be, they were the defendant's statements, and that the constitutional prerequisites, both procedurally and substantively, needed to be met. And Judge Brinkema fairly promptly instituted a mechanism by which those pleadings and certain government pleadings would be filed under seal initially, with a period, I think it was 10 days, for review and requests for redaction, placing the burden particularly on the government to identify material that, either because it was classified or otherwise, wasn't properly placed in the public record, and a default mechanism by which, if those designations were not made and or were not approved by the court, the pleadings would then become public after a relatively limited time. And that mechanism seemed to work quite well for an extended period. The media went back in the trial court once or twice on related issues, seeking relief. And each time the media went back to the court, the news organizations involved noted that the government's concern about national security was a legitimate concern, and the media organizations were not there to argue that under no circumstances could material be withheld from the public in the course of this prosecution, but that the court needed to make an informed and specific decision about each item that the government wished to withhold from the public, and needed to make that decision on the record so that the public could know whether the constitutional rights of access were being honored, and secondly, and more importantly, to evaluate the propriety of the prosecution to supervise, which is the public's role in a very broad sense, the criminal justice system as it rendered justice to Mr. Moussaoui. The issue related to access to witnesses, as Ed and Henry noted, went up on appeal to the Fourth Circuit on interlocutory appeal. And given the body of case law in the Fourth Circuit honoring the public's and invoking the public's rights of access, the public and the news media were quite startled to find that shortly after that appeal was docketed, orders were entered sealing the entire record and sealing oral argument prospectively in that case. And the news media intervened again in the Fourth Circuit to protest those orders. Those are the papers that are in your materials there. And the papers discuss at some length the legislative purpose of the SEPA statute, which was the sole ground invoked by the government for sealing those proceedings. That classified information, material designated by the executive as classified, would have to be presented in the course of the appeal, both in papers and at argument, and therefore they need to be sealed in their entirety. The media organizations gently reminded the Fourth Circuit of its own precedent on that subject and pointed out that a court was required to follow more limited, narrow remedies if any material needed to be protected. And indeed, the Fourth Circuit fairly promptly adopted a mechanism by which all appellate filings would be made public, subject to redaction of specific material designated by the executive as classified, and that oral argument would be bifurcated, that all portions that didn't require discussion of classified material would take place in a public courtroom, and that then the court would go into a closed, secret session to receive information or argument that was based on information designated by the executive as classified. If you look at the reporting based on that oral argument from the journalists who attended it, you'll see that a lot of new information that was not dangerous, did not threaten the national security, came out and was reported to the public and allowed the public to evaluate the arguments about Mr. Moussaoui's request for access to these witnesses. We don't know, that is, we the public, including members of the media, don't know whether all, as Ed suggested, all of the key aspects of the case have been public. We have to accept that on faith because we don't know what, for the most part, what those secret proceedings have been. But because this court in this circuit, not just in this case, but in most cases, does embrace and seem to go out of its way to honor the public's rights of access, there's a basis for us to have faith that many of the key aspects of the case have been made public. That's not true in all jurisdictions. It's not true in all cases in any jurisdiction. But I guess to end where I began, in many respects, this case is sui generis in terms of access issues because of the court and circuit in which it is taking place. And I don't know if this case were prosecuted, even if it were prosecuted across the river, with all respect to the courthouse across the river, whether the same level of access would have been so easily obtained.